we want to understand the rights, we could see another theories, no, about the rights. This is a typical one, Everhard. Right to do something is for heart, faculty to do my will at the end. It has to be with the choice. If I can choose something, I have the right. If I cannot, I have no right. Yeah, this very simple way to understand the notion of right. I don't know, what do you think about this notion? If you agree, or if you think that there could be something that should be improved, or an error, directly an error. Yes, Tasnim.
I guess on my part, I agree with him. That's because based on my understanding of what other philosophers or other scholars have said, maybe I can bring Amartya Sen into this. So he identifies the aspect of capability, and he says that even if you have the ability, even if you have a right in the law, until you have the capability to actually exercise that right, then you don't necessarily have freedom. Okay, it's bringing in a lot of different terms, but generally what I'm trying to say is that I think that choice is very important in consideration of a right, because without choice, you have no ability to choose to exercise that right. You don't have the power to do so.
And you find any problem with that or not?
In general, I have a problem with Hart and his semantics, but in terms of this particular case,
okay, you agree with Hart. Another one?
I don't agree with Hart.
Yeah, why?
It's too brief. A faculty to do my will, just to do something. It's on what basis? I can just choose to go and kill someone. I can choose, I have the right to go and kill, I have the right. It's not based on, it has no grounding, so I don't agree with Hart.
Yeah, Rosalind, yes.
I think I disagree with him, because this would leave out certain groups of people, like children, who they have rights.
This is very important. Yeah. What about children? Yeah, what about children? Yeah. What do you think about? They could have any kind of choice? Obviously not. No. Hard will say, well, but their parents will have the choice. Yeah, but children have no choice. And we can say the same with another people that have some kind of disability, temporal disability, no, and have no parents. No, the state should put someone to decide for him. But it doesn't work, because it's not the right to choose of that man. That is the principal critique to Hart's theory, and the critique was placed by this guy. You know who is this guy? He's a good philosopher. I appreciate so much him. It's called Neil McCormick. Neil McCormick said, well, what happened with the children's rights? Well, it's not a matter of choice. It's not a matter of choice. Many of the rights is not a matter of choice. It's a matter, well, for example, the state can put so many new rights. Yeah, well, or some street. No, you have not the choice to put on a street. Well, you just enjoy the street. Yeah, this is not so well done. That theory obviously can explain some rights very well. Civil rights, for example, civil rights could be explained so very well with the Hart's theory about choice, but some other rights, especially the newest one, well, it's too difficult to develop a theory based on this idea of right. So Neil McCormick proposes us that rights are not something to do with the choice, with the will of the people, but with the interest. He said the purpose of rights is to protect not individual choice, but certain interest of the right holders. For example, the same example that of the critique to Hart, no? Children's right. Well, with children's right, we can see that it's a matter of protection, of protection of the interests of the children, first one. Second one, the people that have some disability, we have to protect them. And then it's easy with this theory to protect all things that you can say that there could be an interest behind of that. For example, animals' rights, no? Or the nature rights. Well, yeah, we will talk about this in this lecture and also in the last lecture of the course. But well, I think that it's interesting because he points out, he stressed one thing that is very, very important in the field of the law, the notion of sense. The notion of for what is the law, for what is the right, for what is so. So because this is a thing that the positivist approach lost. Absolutely. And we have to recover the notion of sense. For what, which is the aim of the whole legal system. No? I think that it is so important. So let's go ahead with Dworkin now. He said that rights are trumps. He understands rights as trumps, no? Well, why? Why? Remember Dworkin, no? He agreed with Rawls and developed the theory of the veil of ignorance of John Rawls. But he says that the first principle is not freedom or liberty. In the first principle is equality, and especially not all kind of equality, but a basic right to equal concern and respect. So, if we take care seriously about this principle of justice, we will see that we will have to recognize to each person the same rights with this principle, no? Equal concern and respect. And that's why all people will have the same rights. But how is the way to recognize that? Well, little by little in a democratic society, we have to promote, to make campaigns in the public space, and then, well, we have to ask to the legislators to enact some Bill of Rights, and finally will be approved one Bill of Rights. And then that will be a win battle, no? A victory, and the rights will be one of the trumps of the society. That's why he said, well, rights should be understood as trumps. So, and he had so many things also, no? He said that all the rights are based in a trilogy that justifies the right-based, the duty-based, and the goals, no? Against the goals. It have some sense. Yeah, it is good to understand that, no? All of them, obviously, this is Dworkin, all of them accept that every right has a correlated duty. Yeah, so if you have in one side a right, there should be another side of the same coin that should be a duty, more or less a duty. We can understand duty in a broader sense, no? But, and here is the problem. Every right has a correlated duty or not? This is the problem. What do you think? There should be two sides of the same coin? Or it could be any kind of right without a duty? Yes, Nancy.
Hi.
Hi.
I agree with him. I think every right has a duty, not duty in the sense that, like, outright states that it has a duty, but in terms of, let's say, freedom of religion. I have that, let's say I have that right, but I also have a duty to not infringe upon another person's right.
Yeah, but this is another thing. You have a, but they say if one person have a right, another person, not the same person, have the opposite thing. Yeah, that is a duty. Okay, Rosalind, yes.
I think that since we established that what rights come about within a relationship, I think it would be true to say that every right has a duty because there are two people involved every time there's a right.
Yeah, but for example, I will put an example. You can tell me what do you think about, no? There is a lot of human rights declarations. In the French Revolution, there was a lot also declaration, well, and specifically one very famous, no? About the rights of the human and the citizen, no? And there was a lot of rights to the property, to obviously to suffrage and so many things, yeah? But in reality, how many people have the right of the property at that time? Not so much, not so much. Well, obviously to some little property, yes. Or to have a house, no? Well, there is in so many declarations of human rights, so many people have not a house. So it's which, if there is a right to a house, there should be another that have to pay that house. You can say, well, I have the right to be in the university, but I have no money, and I will. Well, you can say, well, in the public state, public universities, probably, yeah, but I have the right to have a house. To who you would ask the right to have a house? Yes, Arthur.
I think even in that instance, there still remains a duty, and then it would fall upon
a duty of who?
It will fall upon the government to give an environment in which you can attain that right.
Yeah, you can say, well, an environment, but it's not so clear that there is. You have, and then you have a right not to the house, but to the environment, a good environment to someday. Natalie.
Yes. In the book, when they're giving an example of not everybody, just because I have a right doesn't mean everybody has a duty. There's a part where they talk about, for instance, a lecturer has the duty to teach us, but it doesn't necessarily confer rights upon us. But then I have the question, I still have the right to education, even though it's not conferred on a specific lecturer, it's still conferred on someone, isn't it?
Well, I will try to explain a little. Well, now. Answering your question with this. The theory of the inverted pyramid. Why? Because we can see that if you think the rights in some level will be so different than in another level, no? First, if we think here in the reality can offer us so many possibilities, no? So many possibilities, no? And you can say, well, for example, well, it seems to be that the right of to every people have his own home probably is a good aim to achieve in the legal system. It's a good, and probably all the aims are here, not in the reality, because it's the possibility that we can follow, no? We can seek. Well, but it's just a possibility, and also could be here in the knowledge. Well, yeah, I understand that it's very important to all people to have his own house, or the right to education is so important because we are human rights and we have intellect, and we have to develop first the most important potencies of ourselves. Yeah, so here could be the right of education, the reality, and the knowledge, and in the will. When the government or the society or the French Revolution approves the Declaration of Rights, of Human Rights, for example, well, it's a matter of the will. They are reducing the legal possibilities, the legal potency each time, no? And finally, obviously, in the being, it's so different. Well, as I told you, well, in the being should be there, just there, were two subjects of the law. One, the ones who have the right, and the other, the one who have the duty to pay that thing to that. And for example, the right to a house, well, probably could be just a proposition of an aim, a legal aim. And obviously the state can do so many things, but at the end of the day, it's not so clear. It's probably will remain here. The state will do as much as the state can to provide some cover, some probably to some people, some houses, but not for all people, but as much as he can. No? But on the educations, the government could do so many things, but have to do that things, have to do more acts of the will. They have to concrete the reality, the legal space, until he can provide, because if not, it's just a legal aim, and the legal aim is a programmatic norm that just put an aim, and the state have to try to achieve that aim as much as he can. So we understand better the rights as a trump. So because we can understand that there should be one right, but the will of the legislator will have to concretize to determine which will be the right that will be in the legislation approved. No? That's why it's a matter of the level 2 and 3, rights as a trump. And rights as an effective power are in the level 4. Yeah. Well, I don't think so. We can say that all the rights that are in the Human Rights Declaration and that are in the Constitution of the states and so on, all these kind of rights are just, we will say, potential rights, potential. But potential because they have a lot of space of potency. You know? they could be developed, improved in so many ways, and should be, at the end of the day, well, the being will be so reduced space, legal spaces, as we said, no? But it's more than say that there is no right. Yeah, we say, yeah, it's right, but have to be concretized, realize it in the reality. Well, this is at least one way to explain the right. And finally, I think that all these theories fits very well in Italian theory of the right that I explained to you in the first lecture of this course, and we will take care of that notion now. No, that for sure you remember the notions of subjective legal situations. No, in every legal relationship there is two parts, two subjects: the owner of the right and the debtor. No? And each one of them, well, this is just to show the transition. Well, has his own well, position, situation, with so many well, bonds, titles in front. And I think that it is very clear and very clever, because this is a better way to understand all the positions and all the possibilities that could be in the field of the rights, because the rights could be understood in a broader sense, not just in the four meanings of Hoffel, but more with more meanings. I will put you on some example. No, obviously you will remember the notion of legal relationship. The notion of legal relationship is a relation of complementarity between two subjects, in face of a good, this good, no? In which the first one is the owner of the good, of the right especially, and the other is the debtor. All things understood in a broader sense, obviously, no? And there is a lot of sub-relations, no? Especially here is the relation between the subjects, no? Is the legal bond. The legal bond is not directly the right. The right could be with so many goods that could be in the same legal bond. For example, one legal bond could be an agreement of selling one mobile, for example. Yeah, this is the mobile. He have the right, and he will sell. She have the duty to pay the sale to him. No, but there is another good. No, and the one, this legal bond have two goods: the cell phone and the money. So the legal bond could have so many consequences. No, but he have only the positive side of having the mobile as a property, and she have the property of the money. Yeah, it's another good. And this, so the legal bond had so many consequences, and each legal relationship will have all these situations, the situations of the owner, the situation of the debtor, and the objective situation of the thing. This situation of the owner are the positive situations. We will say that this obviously he can have, for example, a claim right, a liberty, a power, an immunity, and so many other things that probably is not so well could fit in some of the notions of Hoffel or not. For example, competences. The president had some competences to approve some regulation. Yeah. Well, we can say it fits more or less in the powers. Yes, we can say more or less, but not so well always. No, when it is competent or not competent a judge to judge one case. Well, yeah, obviously have some power, but competence is very specific, no? Or the capacities of any people, no? Capacities could be understood in two ways, not the legal capacity to get married and the physical capacity to get married. No? So capacities is not always power. No, and power used to be a public power notion. No? So Hoffel changed, well, he puts public and private powers. Well, faculties. Well, faculties could be understood in so many ways as a liberties also. But the last two positive legal situations could be, I don't think that fits well in any of the four meaning of the rights, you know, of Hoffel. That is an interest. Who has an interest to do well? So many people, obviously, if I'm the owner of one animal, of a duck, for example, well, I can ask some protection. I have the interest, but if I'm not the owner, I have, well, what happened? Probably I will be interested to protect the nature, no? Because the nature is of the humanity. The humankind has all these as an interest. I want to protect, and that's why usually in any country, anyone can say to the policeman, well, let's take care of that because there is someone harming the nature, and that's why, well, all people have interest in on environmental law and can be part on a trial, a kind of part, well, with not so many rights, but a kind of part in the environmental law. This was interest, no? Or consumers, no? You have not to be a consumer of, for example, of an alcoholic drink that could be very harmful, very nocive. You have not to drink that to try to sue the company that produced that kind of alcoholic drink, yeah, because, well, it's too risky for you. But there is an interest of all the society, not only the consumers. Yeah, it is a broader notion, no? That fits not in any of the concept of Hoffel. And by the way, this never will fit another one, the last one of the list, no, expectations. What we will understand about expectations. Expectation is a kind of a germinal right. For example, if you buy one ticket of the lottery, you have the expectation to win the big prize. Obviously, that's why you buy that ticket. Well, it is a germinal right. You have not the right to the big prize. You have the right to be in the game, yeah, but not to win. Well, what happened if the organizers of the prize one day say, no, this week we will not have, we will cancel the prize. Sorry about your payment, but there will be no prize this week. obviously, all people will say, well, I lost the opportunity to get the one prize, and I have a legitimate expectation, and you frustrate my expectation, so I can try you, I can sue you. So it is interesting. There is a lot of case law nowadays with the notion of expectation that I think that doesn't fit very well in any of the categories of Hofflet. Well, and on the other hand, there are negative situations. As you see, positive situations, there could be so many, probably more than the Hoffel's categorization types. And negative, I will say there could be obviously the opposite ones, as Hoffel say, but there, I don't know if there could be a precise correlative well, negative situation. Why? Well, because, well, the imprecision of the language could be a problem, as you saw. First one. Second one, probably there is not just a correlative thing, no? About freedom of speech. Well, someone have to just don't do anything. So there is also an immunity of the power of the president, for example. Also, you will say that well, you have the freedom to do that, and the consequence is that the others cannot do that, anything. But always will be a limit, and because freedom of speech is not an absolute right. So they can do something. Well, there could be so many consequences. There is not one specific negative consequence. Well, I don't know if you have any question about this part of the lecture, of this part of the legal relation. We will see a little more in this one. If not, we can pass to the second part, the four causes of the legal relationship. Don't you have? Okay, don't worry. Yeah, I think that is clear because we have seen something about the legal relationship, and we will see a little more in this lecture. But now I will give you 10 minutes of the break, and we will see in just a minute. Well, in just 10 minutes. Bye-bye. I will left you. Okay. there is so many things in the four causes that you can understand. We have talked in the last lecture and in some other lecture about the four causes of the things, all the things that are in the reality. That's why I think that you more or less have some notion. Grammar is so easy. But now we will be deeper in our analysis of the four causes. For sure you will remember the first one. Example that I showed to you, the example of the table. The table have four causes. Aristotle say that there should be four causes in all the things that are in the reality. Obviously, the material cause, well, is the wood, because this table is made by wood, with the material of the wood. The material cause is the things that that you use to do something. The things that you use to do something. Obviously, the material of the universe. No, the universe have some form and some material. No? It's obvious. No? And on the other side, you have the formal cause. These two causes are the constitutive causes of the reality. Yeah, the constitutive causes. No? The table is not just wood. It has a specific shape, design, form. That's why it's called the formal cause, because the table has some form. This table specifically with 3 legs, and the table that is in the bottom, in the top, sorry. So the final cause is the aim, the end, the goal that the person who do that has in his mind. So we can say that the table have some specific aim that is dining. Dining probably could be many ends. That is a little one step more ahead in the comprehension of the 4 causes, that it will help so much in so many things. It's just not dining, probably could be so many other things. Always could be also, for example, for decoration, for put some pots and things in the table, on the table, to show that things in a museum, for example. No? It's another aim. There could be so many aims. Probably it depends for the person, no? Because what was the aim of the carpenter when he was doing that table? Well, for sure, to sell that table and to gain some money. That's why, no, there could be so many aims. Yeah, and for this person was that, and for the other, the aim was dining, and for the other, for the owner of the museum, to show a specific thing in a good place. Well, so many aims. And finally, the efficient cost. The efficient cost, we can say that could be the tools that the carpenter use to do that table. But again, let's go another step more. There could be so many efficient costs, not just one, because could be the tools, could be the same person of the carpenter, the person, the instrument, and finally it could be the action of the carpenter, the carpentry, the actions to make with the instruments, with the tools, that table. So 3 things in this a simple example of the table, no? The person, the instrument, and the action. Three things. Three things are, in this example, the efficient cause. Yeah. So, probably the formal cause has so many other sub causes. For example, there could be the formal, the accidental form, and the substantial form. We will talk about that. No? But the accident is not the color or the shape, and the substance. No, there is, well, the deepest notion of the. So we will put another example now, not with the table, but with this. I don't know if you know who is or what is that hand with a torch. Yes, Tasnim.
It's the Statue of Liberty.
Yeah, good, so good. And what do you know about the Statue of Liberty? How many things do you know? Do you know why they call the Statue of Liberty? And when it was constructed, built?
I know that it was given to America by Paris, or France rather. It was made in France and then given to the United States as a gift.
Yeah.
And the statue is generally seen, as per the name, as a monument of freedom or liberty.
Yeah. And why in France gave the statue to the United States?
I'm not too sure. I think to show peace.
Yeah. Well, I will explain you. Calvin, yes, or peace, or Calvin.
France is known for heavily supporting the American Revolution because they were against England, and France and Anglo relations have always been strained. So
Yeah.
they supported America's revolution, and they gave it as a sign of kudos for, for fighting off the oppressors.
Yeah, well, probably could be another cause that, but I will explain you a little more about the history of the statue of the United States. In so many countries, the French, they gave a gift of another status, like in my country also, no? But the principal idea of the statue was more than 1 century ago, was the idea of Bartholdi, Frederick August Bartholdi. Bartholdi was an artist, and in 1865, he was in a kind of meeting, a kind of party with so many people. And in the conversation with the people, with La Bourget, another French guy, he said, well, seems to be that in very soon, there will be the first century anniversary of the independence of the United States. I think that there could be a great idea to give to the United States some gift, some present to commemorate this great event of the history of the humankind. So he said they began to think about what could be the present, the gift, and finally he decided what was for sure the best thing that we can do is give them a statue about liberty, and it is very, very interesting because he said, I will fight in that meeting, I will fight for the freedom, and I will ask the freedom to every population, to every town, to every city. I will try to glorify the Republic there in every place, no? Until I find the Republic placed in every place of the world. Yeah. This was the words of this, more or less, obviously, no, of Bartholdi in that meeting. And they think that was a great idea, and he put so many effort, to work in that idea, and he had the next days began to ask to the people some money, to the government, to so many meetings with the authorities of France, saying, well, we have to give something to the United States. And the authorities of France was convinced, were convinced about this idea. And finally, well, it is very interesting. They hired this guy, Gustave Eiffel. Who is Gustave Eiffel? Gustave Eiffel is a friend of Bartholdi, by the way. Yeah, well, for sure you will know Calvin and Peace, that is the ones who built the tower of the Eiffel, no? The famous one that is in Paris. So let's see if I'm able to find another. They let's see. Well, yeah, and at what point the conversations between the government of the French and of the United States began, no? But not directly with the highest authorities, but with the statual authorities of some states. At the very beginning, they were thinking about to give this present to Washington, D.C. They accept, and they say, okay, it's a good idea. Thank you so much. But what happened that all the people of the other state realized that, well, there could be a big present, no? And they were making a new lobby with the French government. And finally, there was a great man, the governor of the New York City, that said to the French, well, I will give you an island, no? And I will put in a very specific place, and I will support to build the base, and I will, well, he offered all things to the French government. So the French government said, well, this could be a great place to put our present, all people will see the Statue of the Liberty, and so they decided this is a great idea. I will follow the suggestion of the government of New York, and that's why now they is there in that island. It's incredible how the lobby can work, no? So at the very beginning, let's see, Bartholdi began to work in that statue. This is Bartholdi, as I told you. He began to make the first designs with the artistic design, and Eiffel, the engineer's designs of the structure, yeah, of the dipsticks of iron, of copper, and all these kind of things. This is a photo, for example, he begins to build that statue. It's very, very interesting, because I don't know if you realize who is the woman that is there. So he is the mother of Bartholdi, Charlotte, and this is the face. This is the face. Some people say that is the face of the mother of Bartholdi. It's not so sure, but in any case, it's interesting, no? Well, this is another part, little part, obviously. This is the place where all the people were working in the backyard of the house of Bartholdi. It's incredible, great backyard. There was the Statue of Liberty at one point. Well, this is some other part. Well, a little statue, this one, but so many pieces. At the end of the day, the thing that all the pieces were made by Bartholdi in French, and there was some ships that came from France to the United States, and finally they used to work there. I will share now again this one. No? So this is very interesting because about the designs of Bartholdi. Who is the face, the model of the face? Well, there is so many theories. As I told you, someone said that is the mother of Bartholdi. No? Bartholdi, Charlotte Becher Bartholdi. Some others say that could be Isabella Eugène Bouvier, a model very famous at that time. But by the way, was a friend, his husband was a good friend of Bartholdi. That's why they say, well, that is very similar, no? And probably he was thinking about that model when he cut the face. He made the face of the Statue of Liberty. Well, some other theories say probably could be another thing. For example, an imaginary face of a woman, not a specific woman. And it is very, very interesting because if you see now with this example, we can find here two kinds of formal causes. First, the original, what is the shape, the figure, the form of the Statue of Liberty? Well, this one, the ones that you are seeing in your screens. But there is a second formal cause, is that exemplar formal cause. The example, who was the example for made that statue? Well, probably could be one of those women, or any idea of a woman. Someone, and it is funny, said, no, it was Elvis Presley, because in some photo you can see that there could be some similarity. Another, no, was Owen Wilson. Obviously, Owen Wilson was no, that probably could be some similarity. But in any case, it's very clear for all the people. If we don't take care about the jokes, that was some woman, the exemplar cause of the Statue of the Liberty. So let's go with another part of the Statue of the Liberty, no? The body. No? The body, well, it's so great. There was so many things, tons of cement in the base, bricks in the base, and obviously with the time, it is very interesting. There was all things with time in this world have some kind of corruption. No? And after 80 years of the foundation of the Statue of the Liberty, there was so many problems, for example, with the painting. No? That's why they decided to paint again the Statue of the Liberty. No? And not once, not two, not three, not four, but so many times. But at the end was a great layer of painting in the statue, so big. No? Also the sticks of iron of the structure were so correct, and that's why in 1982 they decided to change all of these kind of things, no? To make a great reparation of the Statue of the Liberty. At that time, I think that the cost of that probably could be $62 million, because it needs a lot of reparation, no? And 1,300 ribs of the Statue of Liberty were replaced. Obviously, all the layers of painting also were replaced, and was very, very. How much is the weight of the Statue of Liberty? Well, it's incredible. 31 tons of copper, 125 tons of iron, and another 69 tons of other materials. No? At the end, 225 tons of weight. You know. Well, that is the material cost, the materials of the Statue of the Liberty. This is very interesting. No? And it's interesting, all the reparations of 1982. Why is this interesting? Because you can see that people can change. People can, material things can change, but the statue will be the same. This is the idea that I want to show to you. We change a lot, but we remain. And how it's possible? It's incredible. Every 10 years, we renew all our cells of the body. Yeah, we change absolutely all our body in 10 years. But we remain. Melissa, remember that you have to admit the people, no? That is coming. So it is very, very, very interesting, because well, the same happened with the Statue of Liberty. When they realized that there was a problem, they changed all the material, but it's the same statue. It's not another one. That's why we can say that there could be two kind of changes. I will go deeper in this idea. The first kind of change is just to change the materials, but to put the same form. And if this is the same, well, form, there is just an accidental change, no? It's not an essential change, because the same statue remains. But if we could all the statues and just make pieces of the statue, little boxes of iron, little boxes of copper, little boxes of paint, there will be no more a Statue of Liberty, no? That is an essential change, yeah? Or substantial change. With accidental change, well, the statue is the same. With substantial change, well, there is no longer any statue. That's why we talk about two kind of forms. The substantial form, the substance, or the accidental forms, the accidents, the circumstantial things, the colors, the color of the Statue of the Liberty could be so many different colors, no? And will be the same statue. And with lights in the night, we can put some colors or some others or some figures or not, but will be the same statue. This is accidentally changes. These are accidental changes. That is the thing with the Statue of the Liberty. But let's go ahead with now the base, no? You will remember that the base was built by the government of New York City. Yeah, there were so many workers, no? Here, and there is a lot of stories with these workers, no? Because why the workers work? Obviously, because they want to receive a salary, but they realize that probably this is a great project, and some of the workers, when they were putting cement in the base, yeah, they took off from their pockets some coins and put in the cement of the base of the statue, because they say, I will want to contribute to the liberty of the state. No, it's a symbolic act. No, get some coins and to put in the base in the when they are working. They were working. Yeah, as you see, it's not a fundamental cause, but it's a little cause that helps to build that statue. No, it's and symbolic action, obviously. No, but how many people worked there? Were so many people, so many people. There were not just the workers that put the bricks, but also there were the engineers to project that. Eiffel is was one of the great engineers, but was not the only one. And many architects and many people who cares about also the garden in the island. So finally, we have the Statue of Liberty, the whole statue. And we can ask now, I think that you have the whole history, but that will work as a good exercise to understand better the four causes. First question, which is the final cause of the Statue of Liberty? Final cause is the aim, the end, the goal. Yes, peace.
Maybe to symbolize liberty. Yeah, and like as art, I don't say a tourist attraction, but people can go there and see, and they feel as though that was liberty because of the Statue of Liberty. Yeah.
The Statue of Liberty symbolize liberty. Well, this could be any art. But do you think that, but it was not a gift? The aim was to give some present to the United States? Calvin, yes.
In as much as it was a gift, I think Gustav and Frederick probably made it with the aims of being it greater than a gift, as a symbol of independence and liberty and freedom. So it's not the statue in itself, it's the idea it stands for.
The idea that it stands for, okay. And this was not, for example, for the workers, was not the aim of gain some money or gain the salary. Wasn't that aim? Remember, yes, no, Tasnim, yes.
I think that the aim, when you analyze the final cause, you would generally look at the overarching aim. So instead, or overarching aim, instead of looking at, for example, the individual aims of the workers, the individual aims of IFEL, of the architects, of the engineers, of everyone who is included in the project, you look at what was the overarching aim for the making of this statue, of which I think it was what was discussed by Bartholdi and the French, I don't know whether it was the French government or like the French leaders. And that was to, you mentioned, was it to promote liberty? I don't know, you said something about how it was to create a certain impact and show that there is a prominent impact of freedom in all states or in all countries. So I think
that was the phrase of Bartholdi in the very beginning of the meeting of the party that you're right.
I think that is the final aim, as opposed to the individual aims.
Yeah. Remember that I told you with the example of the table that there could be so many final causes. It's just not one. Remember that. But all is a chain of aims, because the workers, it's clearly that they work for a salary. But they decide to work in that, not in another thing, because they think, well, this is a great job. And I will do not only my work, but I will put some money from my pocket in the base of the of the Statue of the United States, that gift to the country. Well, so it's more than a salary, obviously, but we can say that there are so many final causes. And the first, we will say, obviously, the aim is to build something, to build, but the build is just the mean, not the final aim. Remember that we talked in the first lecture, the means and the final aim, no? And the final or ultimate aim. Yeah, obviously, to build is not the ultimate aim. To build an icon, a symbol, to symbolize, neither is the final aim. The gift was an aim. Yeah, to give something. Obviously, it was the aim of the French government. But behind that, after that, there was another aim, no? And a gift who symbolized the liberty, yes. But this also was an aim, because behind that was to promote liberty, to promote the independence, and finally to promote the republic, as you see. Yeah. So it was the idea of Bartholdi, the independent republic. And that was always the main aim. The principal aim is the first in the things that was in that meeting, and the last to be realized. No, at the end we have the statue. That's why this well, after some years you will realize your dreams. No, first is in your mind, and there is in the reality. This is the thing. Let's go now with the agent cause. Who is the agent cause, or what is the thing? Remember that now I told you, well, recently I told you that there could be so many efficient causes. What do you think about? Yes, Rosalind.
I think that one of the agents was Eiffel and Bartholdi as well. They worked together.
Yeah, we can call them Bartholdi and Eiffel, but especially Bartholdi, the intellectual authors of the Statue of Liberty. Yeah, but who else? Who? Yeah, Rosalind.
Can we include the workers as well?
Yeah, and also think about the French government, and also the government of New York, and also the workers, and also the captains of the ship that transported the Statue of Liberty, and also the workers that work with Bartholdi in his house, and so on. No? There could be so many people involved in that project. But probably there was some principal cause. Without Bartholdi, probably there would be not statue, or not the same statue, or not a statue at all. Yeah. Well, I told you something about the material cost. There could be also many material costs, but I don't think that it will help you for understanding law. The other cost is better to know a little more, but we will say that just one type of material cost. Well, material X square. What was the material from what X square, from which place or with material we build in the statue wall, with 125 tons of steel, in addition 69 tons of various materials, and other things that at the end was 225 tons of weight. So the formal cost, who was the formal cost, or what is the formal cost? As I told you, there are an accidental form and a substantial form. So the accidents are, I'm using an Aristotelic language, no? Accidents, the thing that accidentally are, but could be another. There could be the same statue with another color, and will be the same statue, or with a little the shape, no? We can make a little, for example, a little high, or a little lower, or the hand a little, well, we make little changes, for example, making bigger, just 2 centimeters with the layers of paint. Well, there is only an accidental change, but we could, in pieces, all the Statue of Liberty, there will be not the Statue of Liberty, no? The essential change the substance, the substantial change the substance of the of the Statue of Liberty. That's why the accidents could be the shape, the size, the qualities, and the exemplar cause was the model of the Statue of Liberty, and there could be so many things there. And the efficient cause, as I told you, well, the remote efficient cause is Frederick August Bartholdi and Gustave Eiffel. The immediate cause was the French government and the government of New York, and the workers were the immediate one. And the most immediate efficient cause was the action of the workers, the action, because the action is the immediate thing that built the base and the Statue of Liberty. This is very interesting because in all things you can have all these kind of causes. That's why some people, Aquinas said, well, God is the most remote efficient cause of anything, yeah, because he creates the universe. And also is the remote efficient cause of the legal system, because he creates the elements of the legal system with some order. But it's not the immediate cause. The immediate cause of the legal system is the human person. The person, each individual creates a little, but it's not the only efficient cause. Each human. God is the most remote, because without God there is not human, no nature, no things, and with no human, no nature, no things, there is not possibility of right. Yeah, it is very interesting. It is not a direct will of God to create some legal system. It's a remote will of God. Well, we can say so many things about that. And the final cause, obviously, no? The immediate aim is to give something for the century. It was very funny because the aim was, immediate aim is to celebrate, to commemorate the century of the Independence Day. But it was funny because the works of any people used to be with some delay, and the 100 years were not celebrated in the 1876 year, because it was a lot of delay, and I think that was 10 years after that they celebrate with the Statue of Liberty the first century of the independence of the United States. And the ultimate aim, well, it's not just symbolize or take care, it's to promote with a symbol, yeah, the liberty of the states, specifically of the state. Well, with this we can ask now, we understand a little better, we can go ahead deeper and deeper and deeper in this, and I have a book about these kind of things. But we can ask, what are the 4 causes of the law? And this question will put us in the right way to understand the sources of the law. Because, and this is the great idea, the causes, the 4 causes of the law are the 4 sources of the law. This is the good idea. And when we will study the sources of the law in the following weeks, we will study the 4 causes of the law. So we will go little by little. But we can ask also, what are the 4 causes of each right? No? And also, what are the 4 causes of the legal relationship? So we have a way, a methodology to understand better the law, the rights, the legal relationship. We will begin now in this lecture with the notion of legal relationship. And we will say it have 4 elements, no? For the 4 causes, I think that the easiest one is to understand the final cause. What is the aim of any legal relationship? Then why for example, you sell a car or you buy a car, or you buy a house, is the easiest legal relationship. What is the aim of the legal relationship? We have seen the definition, we have seen some elements, and now we will organize our knowledge using the scheme of the 4 causes. The question is, which is the final cause of the legal relationship? Yes, please.
I think it's the good.
The good?
Yeah, I'm not sure. Like you buy something to have the good. You sell something to, I don't know.
Yeah.
I'm not sure.
Yeah, don't worry. It's good to try to think as much as we can. But you're right. I agree with you that okay. Sorry. That is not is the good, but we can say is the common good. The good for not only one person, but for both. Not one subject, but for both. It's the common good of both. Yeah, you agree with that?
Yeah.
Yeah, because remember that in any legal relationship, you have not only the good, and probably when one is selling, the other is buying, no? And the first one is losing, but probably will gain some money, and the other is acquiring one good. So we will say that in the legal relationship, the aim for both is the thing that is good for both, the common good. Yeah. Okay. So let's go again with this. And which are the material, the things, the elements that we need, the physical elements, the material elements that we need to have any kind of legal relationship? Well, I will say you, because I see that it could be a little hard for you, but it's not so hard. Obviously, is the good first, then is the subject, the owner, and the debtor, and then we can say also the environment. These are the material elements. Without of this, we have not right, not any legal relationship. Yeah, we need these kind of things, and if we put, and the form is the relations between these elements. No, if we put together the ones who wants to sell and the ones who wants to buy, well, we will have a legal relationship there. They will. So the agent, obviously, the efficient cause is the action of selling. Is the action. Remember, the immediate efficient cause is always an action. Always, we can understand it as a person also, but especially the action of selling, the action of buying. Well, and we can say many things. Probably and finally, the form. Well, the form we told. We said that is the form of the sub-relations. The legal bond, the claim right, the positive title, the negative title, the duty. All these are the form of the relationship, have a specific form. And remember, the legal form is more, could have so many consequences, so many claim rights, so many duties. For example, between parents and children, where the legal bond will be established in the contract of buying. Well, it's the contract, the legal bond. And there will be so many possibilities with the things. If you pay, if you don't pay, but the contract will be remain. No? If you don't pay on time, there could be some fines, well, so many things. No. So there could be two kind of legal relationships, legal bonds. No, one of them necessaries and other non-necessaries. Necessary for the will. For example, I cannot decide who will be my father. Yeah, it's a fact. It's a fact who is my father. I cannot decide. It's necessary, not necessary. I can decide if I will sell my mobile or if not. So let's put an example with this painting of Morgan Wasteland. This is my favorite author, my favorite painting. He was a painter for Hollywood. He used to paint the storyboard of the films. Before the record of the films, they used to paint all the scenes in a booklet to know more or less where they have to put the lights and kind of. But Morgan Wasteland did so well his job that at one point he decided to be alone. He paint his painting alone. Now it's very famous. And this is, as you see, well, a typical scene of a family in the county, which, yeah, I don't know, it could be in a farm. How many legal relationships you see here? And what kind of legal relationships? Rosalind, yes.
I would say 2 or 3. I think the
Which one?
relationship between the parents and the children.
Yeah.
And the parents themselves and family.
This one specifically, what kind of duty you see here?
A duty to provide food. I don't know.
Yeah, good. Okay, which other legal relationship?
The one between the parents. That one was between the children and the parents. Now between the parents themselves.
Yeah, could be. Yeah. The marriage, it's very clear. A specific relationship. And another?
I don't know if a relationship between the human beings and the animal. I don't know.
Yeah, probably could be. Yeah, the owner of the pet. And who is the owner of the pet? Probably all the family. This guy that seems to be a friend of the family that is with a cop will probably have to respect that ownership. And there is also, what, any other? I saw so many here, so many. Georgina, yes.
I'm not sure, but the relationship between the siblings, the children.
Yeah, between the siblings, okay. What kind of debt could be? Duty or right?
I'm not sure what kind of.
Yeah, that's why. Probably some kind of solidarity debt. Okay. Another ones, yes. Yes, Betul.
So I'm not sure if this will apply, but could there be a relationship between a duty for the young boy to keep the fire going?
Yeah, probably could be. The parents could ask him with the power of the parents, obviously, to ask some duties. Yeah, probably. Calvin, yes.
Okay, maybe on the side of the dog, the duty to provide security.
Yeah.
On the side of the child, the duty to promote herself to be involved in her education.
Yeah.
Father,
Yeah, that's clear. You can see the girl with a book writing something. The right to education. Yeah, the right to education is a potential right, but this is very specific because the parents have to give to their children some education. Yeah, you're right. And
then there's also the privilege of the father to play music.
yeah, play music. What kind of right is?
What kind of?
Right.
Is it? I don't know. I was going to say right to entertainment, but that.
Yeah, it's related, but also freedom of speech. Yeah.
Yeah, freedom of. Yes, exactly. Actually.
Yes. Okay. Well, what kind of things are you trying to show you here? Well, first, the evident thing that the law is a dimension of reality. The law is not a superstructure, as Marx said. Marx was seeing only the one level of the legal system, the being, no? And this view, he has some truth. But principally, law is a dimension of the reality. You have to understand better the reality, and you will realize that there should be one duty, one right, or so many relations that have the dimension of the legal relationship, obviously. It's not artificial. Law is not an artificial artifact. It's have to do with the reality. And if we understand better the reality, we will understand better the law. So let's go now to trying to understand the human being.
Sorry,
Why?
sir. Before we move on, I'd just like to ask, in relation to the picture, could you also say the duty between the individuals and the property? So the right to own property, the right to resell the property.
Yeah. You can see, I think at least 10 kind of legal relationship. 10 kind, yeah, and probably so much more. Yeah. You're right. You're right. Absolutely right. So let's go again with this last one, because the idea is try to understand better the material elements of the legal relationships to understand better the law, the right, and the legal relationship. No? And we said that there were three elements, no? The good, the human being, and the environment. Well, this lecture, we will try to understand at least a little better the human being. And that's why I will talk about this first element of the legal relationship. But before to do that, I will remember some notions of the history of philosophy. A brief history of philosophy. In the very beginning, the very first concept is one of Heraclitus, movement. We can see that things moves. No? There was a problem. He never understood very well what is movement, but he realized and discovered that it's a great thing. The second concept is being. So it was an intuition, just an intuition of Parmenides. So many people say that he was the founder of metaphysics because he realized that the things are. Whatever is, and what is not, cannot be. And that's why he said, if things are, there is no movement. The movement is just a thing that seems to be, but in the reality, there is no movement. No? Our senses, well, never say the truth to ourselves. No? The next discovery of the philosophy was the discovery of potency. We will talk about so much about this. of Aristotle, no? And the potencies, but not only the potencies of the nature, but also a rock can be a part of the Statue of Liberty. A rock, no? It's a potential, a possibility of that rock, no? But also he distinguished the potency of the intellect. The intellect can be the rock when the intellect understands the rock. The will can be the rock when the will desire the rock. No, but this just a potential ability, no. And with the potency, he distinguished the substance and the accident, as I told you, no. Then the next discovery was the act of being. Aquinas. It is very important. Aquinas realized that the Greeks always were talking about the mode of being. The mode of being. The mode could be a substantial or accidental mode of being, and an actual that is now, or could be as a possibility, a potency, or that was not, no, but it is just mode of being, yeah, but not that the things are. That intuition of Parmenides, Aquinas developed so much. Being is not a mode of being. All of the Greeks talk about just a mode of being. And finally, I will say that Leonardo Polo in the last decades, the last century, discovered another great concept, that the person is the act of being. It is so deeply, I will not explain so much about this, but this is interest. Now, it's not the same to be than to be a human. The human is the nature, is the mode of being, the mode of being, the essence. Now, we will see something about the human person. What is the being? As we talk about is the act of being, is the not only the existence, obviously. Being is a consequence is that all things that have been, have existence. For example, and you can distinguish this with nature, no? Nature could be a concept that is in your head, in the human nature, that could be in your mind, yeah, the human concept of human, the concept of human being. But this is a mode of being. I have in my mind the nature, but there could be no human life in the world, just in my mind. Yeah, obviously, we need something, a different notion, not mode of being, but existence. So, and the mode of being is the second concept that could be, is the essence. Essence, the notion of essence is the mode of being. And the essence could be the substantial form or the accidental form. I told you what is that. And in the human, the soul is the substance. If you have this, that's why you can change all your cells or your body, and you will be the same. You will be the same. You are yourself. Every 10 years, you will change all your cells, all the material, because but the substance could be the same, no? And the body, or the body, the accidents are the colors, the weight, equal of the Statue of Liberty, and finally the nature. What is the nature? And the nature is mode of being. First thing, nature is mode of being. But and this is the important thing, it's not just the essence, the mode of being. It's the essence, the mode of being, as a principle of operation. So, when we see the nature, we see how the things operate, how each nature moves. For example, well, a person, the nature is an individual with intelligence because he can think. Yeah, a dog is a quadruped that barks. Yeah, it is, well, the same thing that I said, but I will add now. That the dog is alive. Is obviously a dog is an animal, and because it's an animal, is an element that have life. What is life? It's a principle of self-movement. The next question is when the human life begins. When we can say that there is a human individual, which is the very beginning. And I will put you now 2 videos. When it explains something that for sure you will know, how the people, how is the fertilization. In any case, I will share you also that video in the chat, because probably someone can have, yeah, now you have all the links of the videos in the chat, but in any case I will put you here. I need to explain how is the fertilization, and the question that I will ask after the videos is when the human life begins and why. And you have to, at least I suggest you to try to resolve that question with the notions that we have seen. So first I have to share my computer. Okay.
Videos, please visit Facebook Armando Hasurian. This is going to begin. So here we have the reproductive tract, the uterus, the vagina, cervix, fimbriae, and uterine tube, also known as a fallopian tube. And here, coming out of the sides attached to a ligament, are the ovaries. Ovaries are female gonads, and ovaries are what will produce the female egg, the oocyte. Women go through a cycle called the menstrual cycle each month, where they ovulate and they release an egg called an oocyte. This process is called ovulation. Here we have the oocyte, which is surrounded by a thick protective membrane called the zona pellucida. And surrounding the zona pellucida are cells of the corona radiate. If this oocyte, this egg, is not fertilized by a male sperm, what is known as a basically period occurs. However, if there was a bit of sperm swimming along in the uterine tube, and then the sperm meets and penetrates the oocyte, this process is then known as fertilization. The sperm is able to penetrate the zona pellucida using special enzymes on its head. Anyway, once fertilization occurs, a zygote is formed. A zygote is a fertilized egg, and this is our day one.
Day one.
The sperm's DNA and the oocyte's DNA mix to form literally one cell. That one cell then divides into 2 cells. Those 2 cells then divide into 4, then 8, then 16. This whole process, which occurs along the the uterine tube, is known as cleavage. What's interesting to know is that as these cells keep dividing, the whole structure actually does not get bigger, but the number of cells increase. And so they just basically they become compacted in this structure. And these cluster of cells are still within the zona pellucida. When there are about 16 cells clustered together in a ball, this collection of cells is known as a morolla. And by this stage, it is day 4, post-fertilization. This morula will divide again and form a blastocyst, which is a collection of 32 or more cells. These cells that I'm talking about are essentially embryonic cells. So all these cells within the blastocyst are embryonic cells. The blastocyst is still surrounded by zona pellucida. The blastocyst will now implant into the growing uterine wall. The blastocyst I am drawing now is a cross-sectional view of the blastocyst. So we are cutting it in half and we are looking inside the blastocyst. So this blastocyst implants, and this is about day 7. Before the blastocyst implants, the blastocyst actually will shed the zona pellucida, which, if you remember, was the membrane surrounding the oocyte initially. In the next video, we're going to focus on implantation. Thank you.
Okay, this is the first part, and I will put you the second part.
Within a week of conception, your fertilized egg, known as a blastocyst, will make its way to your uterus. The egg is about the size of a pen tip. In days, the cells in the egg arrange themselves into groupings. The inner cell mass will become your baby. The outer cells will become the amniotic sac and placenta. The blastocyst then sheds its protective casing in a process called hatching and burrows into the lush uterine wall. Around week 5, your developing baby is the size of a sesame seed. The cells that once formed the blastocyst's inner cell mass begin organizing and arranging, giving shape to the young embryo and forming primitive organs. Your baby's brain and spinal cord are visible through his translucent skin. Right around this time, your baby's circulatory system also forms, and his heart begins to beat. Your baby looks more like a tiny tadpole than a human. He's drawing nutrients and oxygen through the newly formed placenta and umbilical cord. By week 9, the embryonic tail is gone. Your baby's looking more human every day. With protruding limbs and fingers, a defined nose, mouth, and eyes, and tiny earlobes. Your new resident is about the size of a grape and weighs a fraction of an ounce. It's hard to believe how rapidly one cell evolves in such a short time into the unmistakable body.
Well, okay. The question again. When we can say that we have human life or an individual of the human species, and why? This is the first question. When and why? Day 1, day 5, when it's in the uterus, after 2 weeks. When and why? Yes, please.
I am not too sure, but maybe in day 1, because once that whole process has happened, once I think it was the fusion happened, every other stage is just going to happen, and eventually a baby will be formed. So yeah, I think
when the process could begin, the process begins with the agreement of marriage. Yeah.
Okay.
This is the very beginning of the process, and then we can say probably there are so many things before the fusion, no, or the syngamia, that is the same. Why that Yeah, why the question? Why there is an individual different from an human individual and human life? Yeah. Another, Arthur. Yes.
I think at that point you can no longer say that that being is uniquely you or uniquely someone else. I think it's at that point it's a combination of more than one individual.
And why? But is unique or not there? So many people say no, it's part of the body of the woman. Why we can say that it's unique? Rosalind?
Can we say it's because it's generating its own cells?
Generating frontal cells.
It's
Yeah.
generating its own cells.
Yeah. It's generating its own cells. But I am trying to show you that there could be so many problems, no? Well, the sperm, well, it's not needed. Well, or the egg of the woman to develop that. Yeah, obviously, you have some reason, but why we can say that there is human life first? We have to define first what is life. What is life? Rosalind, yes.
We had in the previous slide, it said that life is the intrinsic principle of self-movement.
Yeah, we can define life with just one word: self-movement. The philosophers used to put so many words to explain the self-movement. For example, they say that self-movement is a intrinsical movement, that is self, that is a movement of the same thing, no? An intrinsical movement. And not only, but an intrinsical and autonomous, because it's self, autonomous, no? It's a principle of movement that is inside of the thing. And we can say, for example, that this is the difference between machines and animals, no? In animals, you have the principle of movement inside, or in plant, or in any tree, for example, no? You can see that the principle of movement is in the seed, no? There is all the principle of the movement, no? If you put this, the seed, it will grow and it will be a big tree, but all the things are in the very beginning, no? And with the animals, exactly the same. And we can see that after, we can see so many things, people say, well, it's not enough to see that there is life, because it's obvious that the zygote and the morula and all of them have life and human life, because it's not the life of a dog or a duck or a lion. No, it's a human life, but also have human life the sperm, and also have the human life the egg of the woman. But it's so different. It's so different because the life of the egg or the sperm is so different, because the movement, the principle of movement is not enough. Just and the sperm can live just a few hours, and the egg of the woman just also a few hours or days, yeah, but always with the help of the mother. In any case, cannot live 80 years like a human. But it's so different when the fertilization occurs. It's so different because there is all the principle of movement, of self-movement. With the ADN, we have the same form of the human that will be subsist all the life of this individual, all the life. When we stop to grow, well, probably with the death, yeah, as a seed. No, when a seed stops to grow, well, with the death of the tree, yeah. So we will say that the individual is in the fertilization, and that is another concept that we gave. I gave you in the last lectures. There is the whole human nature, but in potency, and this is the nature. Nature is the potency, it's not the actions. Yeah, remember, Aristotle was trying to understand how we know. And he said, well, there is a potency that is the intellect, and that's why people that sleep have also the intellect, no? Or people that are sleeping or with some disability are also persons because they have intellect, but in potency. In the fertilizations, you have the self-movement principle that is called life, yeah, and for 80, 90, 100 years, it depends of so many circumstances. So you have the very beginning of the human individual at that point, and that's why from that very beginning there is you have all the rights as a human individual, no? And Tertulliano used to say that if we don't say that there is human, there will be never a human. And this is the problem with all the theories pro-choice, no? That they say, no, there is not human, there is just a part of the body of the woman. Yes, but if it is true, when is the beginning? And that is the worst question for the pro-choice movement, no? Because some of them say, no, in 5 days because, or in 6 days, or in 7 days, or after 2 weeks, or no, and so many say, no, hey, well, you can choose to kill your baby before the birth, before the birth. So there is no clear day that they, because there is no clear argument to say when the individual begins, and the individual as individual begins with the fertilization, but because once again, these have a human life, and individual human lives that can, if you that process, some true, you say no, that process will end with the death, obviously, of the person. But you have all the information, all the form of the human, all the form in the ADN. Yeah, if you change the form, there will be another species. Yeah. So it is important to understand as much as we can these kind of things, to realize that, well, when is the beginning, and to understand better the subjects of law, because the first and most important and the only essential subject of law is the human being, yeah, the human individual. What is the subject of the rights? Well, we have seen the first lecture that the subject of law is the one who is considered the center of attribution of legal subjective situation. And we will see now that there could be two kinds of attributions, no? One direct and another indirect assignation of subjective situations. Directly to the human being, this direct or indirect. Yeah? Indirectly, how can be indirectly assignations of subjective situation with companies? With a company is what you are doing when you create a company. Well, you say, well, this I don't know, this land is not of some specific person, but is of the company. But who is the owner of the company? Obviously, there will be some actionists, some shareholders, that at the end of the day will be the ones who have the power with that land to do whatever they want. Yeah. So any company is an indirect assignment to the human being. If there is not human being, there is no company in this world. I don't know if you realize that. No? Yeah. What is a company without any human being? It's just a name. It's just a folder with so many statements, and it will never work like a company. Any entity, legal entity, fictitious entity, needs the human will, the human intelligence. So now we can go one step more ahead with the definitions of subjects of right. So depending the level of abstraction, there could be so many subjects. Yeah, companies, entities, associations, human beings also. Can animals have rights? Can nature have rights? What do you think? What do you think? There is so many case law around the world nowadays that says that animals, for example, a monkey have rights, or a chicken have rights, or a river. In Colombia, the river have some kind of right. We can say that they have rights. If it makes sense, yes, Tasnim.
Okay, so I want to try because I'm not sure if I'll be able to give a very informed opinion. But I think, well, based on everything that we've spoken about so far in terms of the causes and understanding a human being in general, I think the major distinction between a human being and an animal is to do with the intellect. So yeah. Animals are purely based on their sensitive being. So they think with their senses, and everything they do is very purely based on senses. But man, and a will in which you're able to okay, sorry, you're able to, I'm so sorry, I got a call. You're able to I'm trying to find a word but I can't remember it, but you're able to contemplate the consequences of your actions and able to contemplate what an action means. And so I don't think that animals have rights, because if you even look at the basis of the legal relationship, it's formed on the basis of rights and duties, and the fact that man as an individual has these rights and duties as a consequence of their actions and their intellect.
I will put another question more curious. Can a simple table have any kind of right? Not animals with life. Obviously, an animal have no will, no intelligence. There probably some intuition could have, no? But I will say yes. And from many time ago, there 8 centuries, this table have some kind of rights. 8 centuries ago, which is this table? Well, it's the table of a church, a Christian church. and it's very interesting because there was so many problems in the parish of so many places, because, for example, the people of the parish used to give donations to the parish, and the priest received that donations. But when the priest was moved to another parish, well, they used to go with all the money that the parishioners gave him. And they say, no, but the money was not for you, was for the parish. So this guy, for Genibaldo de Fieschi, that became a pope in that year, developed a doctrine that this is the doctrine of fictional entities used for create companies and associations and for that. And he said, well, we have to distinguish between the member of the associations and the association itself, because probably it will work like a human being, That's why it's a fiction. It's a fiction created by our mind. So if we can give rights to a table or to a name, any company is giving rights to a name, but at the end of the day, who is the owner of that right? Well, obviously the human being is an indirect association. Obviously, you can give not only a table, but also an animal or the sky or the whole environment. For example, in Ecuador, the whole environment have a subject, personality, legal personality, legal subjectivity. The whole country, in the whole country, the environment of the whole country or the world, I don't know. Well, in any case, yes, we can give to whatever we want, right? Whatever, a table, an animal, an environment, a river, a rock, a name, just a name. Coca-Cola is just a name and have so many rights. The company, Coca-Cola company, no? But at the end of the day, without human being, there will be no right. That's why it's an indirect assignment of right. And if we understand this, we can develop more the theory of subjective right. Because first, human being have legal personality and rights. Then dogs, cats, rivers, monkeys, nature, table, and just a name can have a right. And even more, we can say that some kind of subjectivity of personality, of rights, can have the positions, the civil status, married, not married. If you are married, for example, you have not the right to marry another husband, for example. Well, this is a limitation. And if you are not married, you can marry with some husband. So we will say the positions, the positions of the delegate or the position of the ministry have also personality, some subjectivity, some kind of subjectivity, but it's a figure, an institution created by our mind, and that's why it will never work the same as human beings. Human beings have wills, and the other things, the nature, the companies, they have not will, and that's why always there will be behind of the company a representative, a management, a general management person that is taking care of the things. Also with the nature, in Ecuador, there is some people that are in charge of the nature, obviously, because animals have no will to protect their interest. No? So this is the idea. No? There could be more abstract elements, subjects. And finally, we will say a word, just a few words about why we obey the law, or why should be obeyed. I don't know, what do you think? For what reasons you obey the law? Because it's someone that will punish you? Yes, Rosalind.
I think we obey the law for our own good, because we know that it's good for us to obey the law.
It's good for us. It's good for us. Okay, it's a possibility, it's a reason. Some other? Duta, yes.
I also think that we obey the law to avoid anarchy and disorder, so to have some form of order in the society.
Yeah, okay, that's good. Lisa, good to hear you.
I think we obey the law to promote the common good.
Yeah, well, you are always with the classics, all of these answers. Good. Catherine.
I'd say we obey the law because we have a duty to obey the law.
A duty to obey the law. And what kind of duty?
It could be
a moral duty or a legal duty?
I think it could be either.
Okay. Well, authors used to put so many reasons. The typical one is because there is a moral reason behind that. Morality asks to obey the law. The law itself cannot ask to obey the same law. This is a circular argument. No? Some other says that we put our consent or will in the social contract of the society in some way. Obviously not signing any kind of agreement, but if you are in some country and you don't move to another country, you are accepting more or less the legal system of that country, no? So another says that the law requires that obedience, and it is very related with the argument of coercion, of coaction. You should obey the law because the law, if not, you will be punished. You will receive some sanction. So also penalty. So we can say, yes, but what happened with so many people that never put his will? For example, prisoners. What happened with the prisoner? I think that no prisoner wants to obey the law, wants to be in the jail so many times, so much, well, suffering so much. Obviously, they don't want the legal system. And that's why we will say that it's not so clear, no? Hart have a theory, interesting theory about fair play. He said, well, it's because if not very good to disobey the law. My disobedience is wrong since I'm taking an unfair advantage. And we have all of us to be more or less equal, and it's unfair. It's unfair play. Yeah. Well, it's interesting. Other authors say that it's a duty of gratitude. is a duty of gratitude. I don't know what you think about this, but it is very clear that we receive a lot from the society, and we give not so much. Not so much. How many things you give to the society? Well, probably some help, some support to somebody, but you receive from the society all the streets from the country, the education, so many cultural ideas, and so many machines and discoveries, and so a lot of information. Instead of that, we don't give so much to the society. So we have a duty of gratitude for the government, and how we will correspond to that. No, well, obviously obeying the law, they say. No, and they say it's more or less like Hobbes, like Hobbes, that say we obey the Leviathan, the big monster, because he will give us peace, well, and some order, and probably some other things. More or less the theory of Thomas Hobbes. I don't know if you agree with some of these, but probably theories, probably all of them have some reason, no? But probably the reason that you said, that is also the classic moral argument, the common good, the welfare. If you ask probably to the people of the street, many of them will say, well, it's not a matter of coercion. Some of them say, well, especially the bad guys, no? The bad guys of Oliver Holmes, no? The definition of law. Well, as to the bad guy, what things have to obey, it is the law in that country, no? But we will say it's not just a matter of coercion. Why you should used to go when you drive a car in some parts of the street and not in the other side? Because you realize if you are in the other side, you will have so many problems, you will crash. So you will have so many accidents. And so you realize that without any coercions, it's good to be in some side of the road, in some side of the street, when you are driving a car, no? It's very, there is some reason. No? Law is very reasonable. It's very reasonable. It is, and to obey the law is very reasonable. If no one fulfilled his obligations in the agreement, well, I will not have any kind of security to buy and to sell. It's not a matter of coercion of the state. No, it's not a matter that there will be someone who will punish me if I don't do that. No, it's because I understand that it's good. Remember Milgram experiment, no? People used to do that not because there was any kind of coercion, that there wasn't, no? Because probably could be an unconscious ideas. So I don't know which one of these theories you have. Probably the three of you that said something with the common good, because you realize that there is a good behind of the laws, but probably I think that all of them have some reason, but especially the last one. If we, because it is reasonable to obey the law, and we discover some reason, no? And is some moral reasons, some legal reasons that are behind of that, and we realize that there is some good at the end of the day. And And when we realize that there is no common good, well, we will disobey the law, because this is obviously against society. No, if Hitler asked me to kill someone, well, this is the law, but there is no common good in that word, no, in that commandment of Hitler, no, and that's why you have the right to not to do some things that even could be in the law, in the positive law. Yeah, that's why I think that is the final idea. Well, with this, we can finish the lecture. If you have so many comments, question, or anything, you can ask me by email or by any other chat. Nice to hear you, to see you, and bye-bye.
Bye.
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 Good afternoon.
Bye.
Melissa, you have to stop the recording, or